Hi all, sorry for the delay. It is time for panel 3, which will examine present day issues of the disability frame. Before we get going, we need our first CLE announcement of the day. And I'd like to bring up Ashlyn to make that for us. Ashlyn?
Hi. If you're seeking CLE credit for today's event, please note the CLE passwords will be announced twice per hour. Please write down these passwords and enter them on your digital evaluation form once the event is over. The evaluation form is mandatory to receive CLE credits. The link to the digital evaluation form was emailed to you in your event reminder email. But if you did not receive this email, please find the link to the evaluation form in the chat. I will put it there now. These passwords will tell us how long you attended the event. So the first password for this panel is CHIP, C-H-I-P, CHIP. Thank you.
Thanks, Ashlyn. And again, this is Matthew. I'm going to read our access statement one more time. We've had a lot of people join us since the start, and again, want to make sure that we set our inclusion guidelines, our access guidelines front and center. We strive to be as inclusive as possible. To that end, here is some information about how this event will go. We have ASL interpreters, Donna and Joy, and also manual closed captioning as standard accommodations for each panel and speaker during the symposium. And again, if you need to pin our ASL interpreters in order to make them bigger, that is the way to do that, through the pin function. We will orally identify ourselves when we are speaking. When we are speaking for the first time, we will describe our visual appearance. In all instances, we will state our name before we speak. If a speaker shows a slide, they will describe and explain what is on that slide. And we encourage participants to use plain language wherever possible and define acronyms or avoid using them altogether. We have a few channels by which to ask questions. Anybody may type a question in the Q&A tab, and that's the Q&A tab and not the chat. We will have a moderator read questions unless the person asking the question prefers to ask orally. To ask your question orally, please indicate you would like to do so in the body of your question, or alternatively, you may simply raise your electronic hand. We will then allow you to unmute yourself to ask your question. Finally, we will have a phone line where anyone can call in to ask us a question. That number is 215-898-7060. You may also use this number to make accommodation requests or report technology issues. And you may also alert us to issues via the chat. That statement is in the chat, as well as on our website and on our Dropbox. All right, and again, this is panel 3, examining the present day uses of the disability frame. We will hear remarks from Katie Eyer, Jamelia Morgan, and Conor Dwyer Reynolds in that speaking order. Shaun Ossei-Owusu will then deliver a short comment and invite questions from the audience. Biographical information about the panelists, the participants, is available in our symposium program. I'll now give the floor to Professor Eyer. Professor Eyer.
Good morning, everyone. I'm delighted to be here. My name is Katie Eyer, and I am a white woman with short, light brown hair, wearing a black suit and a colorful scarf. My pronouns are she, her. Thank you so much to the amazing conference organizers for your vision and for your hard work, and to all of you for joining us here today. So I'm going to be speaking here today about a subject that I've been thinking and writing about quite a lot recently, which is the question of claiming disability as an identity, or perhaps more precisely, why it is that so many of us do not claim disability as an identity. Although I've written academic work on this subject, as have several others participating in this symposium, today I'm really going to be speaking primarily from my own experience embracing the insight of critical race scholars and critical disability scholars that narratives and individual stories can hold important truths too. But before I turn to my own experience, I really wanted to take just a moment to situate what I'm going to be talking about within the themes of the conference, the benefits and the costs of the disability frame. And I'm sure most of the people attending this symposium know well, we have today a vibrant international disability rights movement, and we have here in this country any number of critical disability civil rights laws. So it may seem quite natural to us today to speak and think in terms of disability civil rights and disability anti-discrimination law, instead of, say, rights for the blind, or for folks with spinal cord injuries, or for those with mental health disabilities. But of course, the fact that that seems natural and easy to us today is, of course, because of the hard work of disability advocates to break down different silos and to build a common sense of identity among those with brain and body difference across all of the many forms of brain and body difference that exist. To some extent, this work has been spectacularly successful. Today, we do not think twice to identify a wide variety of physical and mental health conditions under the unified label of people with disabilities, and to think of our civil rights, our rights to anti-discrimination and anti-subordination collectively under the label of disability rights. But where the movement has been less successful, and where perhaps even today there may remain ambivalence about what constitutes success, is in persuading all of the constituent members of the movement that they are people with disabilities. Indeed, right now here in this symposium, there no doubt are more than a few people who have conditions like diabetes or a former cancer diagnosis, an autism spectrum disorder, or a learning disability that significantly affects their learning. People who are people with disabilities under the Americans with Disabilities Act, and yet do not self-identify as disabled. Well, the decision whether or not to self-identify as disabled is a deeply personal one, and I certainly don't want to suggest that any individual needs to embrace that identity for themselves. I do want to suggest that the current state of affairs, where many people who qualify as disabled under civil rights law do not self-identify as disabled, has costs. It has costs for the disability civil rights movement, and I think that it can also have costs for those of us who may struggle to embrace a disability identity for ourselves. To be clear, I am not suggesting that the disability frame was the wrong choice for the civil rights movement built around brain and body difference. I think that the disability frame has offered a tremendous amount of power to the movement and a sense of community that is, quite frankly, astonishing given the vast, messy diversity of disability experiences that exist. But I also think that it is important to pay attention to the fact that the frame within which we have chosen to situate these key civil rights is one that is fraught for many of its members, and that indeed some of its members reject as a label and as an identity. So that's the backdrop. That's how all of this fits into the symposium themes. I'm going to turn now to talking a little bit about my own story, which is, of course, just one story of a messy, complicated journey to disability identity. Really the story of how I found my way to such an identity, as well as the ways that doing so has been transformative for me as an everyday advocate for disability rights and justice. So beginning my story, my longest and most central form of brain and body difference is not a visible one. It's major depressive disorder. As we probably all know, major depressive disorder is exceedingly common in the legal profession in particular. But for me personally, it long predated my status as a lawyer, and indeed any thought I even might have had of becoming a lawyer. So I remember fourth grade as the year that the world went dark, as if the light and happiness had been sucked out of it. By middle school, I was actively suicidal. I had chronic anxiety. I lay awake for hours at night trying to fall asleep. As a teenager in high school and beyond, I made suicide attempts. I was a pack-a-day smoker who burned cigarettes into her own hand. I hitchhiked, I slept in bushes. I did literally all of the things you might imagine that someone desperate to escape her own mind and her own life might do. Even today, after having helped to win a major Supreme Court decision for LGBTQ equality and having many other tangible accomplishments, I continue to consider it the greatest accomplishment of my life to have survived those first 15 years without mental health treatment. So why share all of these deeply personal details of my life at an academic symposium of my law professor peers? To be honest, I have asked myself that question more than a few times in preparing for this talk. But I also know that mental health disabilities remain incredibly stigmatized in the legal profession, as do other forms of neurodivergence. Even though, to be clear, mental health disabilities and neurodivergence are incredibly common in the legal profession. And I'm also really aware that there are many law students out there, including perhaps law students on this call, who deserve to hear that their mental health disabilities and their neurodivergence, even if they are not the sort of pretty and respectable kind, deserve to know that that need not keep them from being a 100% kick-ass lawyer. And just to put the punchline on it for any students with brain or body difference who may be attending today, all of us at this symposium are rooting for you, and we know and recognize just how critical your voices are to the legal profession. The final reason I think it may be helpful to hear some of these details is that it helps to explain why it is to me today rather perplexing that it honestly did not even occur to me to think of myself as a disabled person during this time frame. Even several years later, as I started to contemplate a career in LGBTQ and disability rights, I thought of myself as pursuing disability rights for other people in my family, for people who had schizophrenia or schizoaffective disorder, or other more quote unquote serious mental health conditions. And so it was not until 2019, after more than 30 years of living with major depressive disorder, that I even began to truly contemplate the question of whether I might be a person with a disability. When I finally did, it was driven by a collection of factors, both personal and professional. So professionally, as a scholar, I was examining the fact that there are many people who qualify as people with disabilities under the civil rights definition, and yet who do not self-identify in that way. And of course, intellectually, I knew that I was one of those people. I clearly am a person with a disability under the civil rights definition. Indeed, major depressive disorder is specifically listed by the EEOC as a condition that should, as a matter of course, qualify someone as disabled. Around that same time, I also was confronted by the cognitive dissonance of raising children with mental health disabilities and other types of neurodivergence to have strong positive disability identities, even as I continue to reject such an identity for myself. So without being specific, I will just say that my children have not escaped the genetic blessings of two family lines chock full of neurodivergence and mental illness. And that means that they've had to learn to navigate all of the struggles that brings with it, having to work harder at school, anxiety, stress, depression, attention difficulties, and of course, discrimination from society. Especially for my oldest son, who is open about having an autism spectrum disorder and dyslexia, forming a strong positive disability identity was critical to his ability to embrace his own self-worth, even in the face of discrimination and struggle. But of course, this raised the question, what about me? If I thought a positive disability identity was so valuable for my kids, and I did, why not for me? So there's a part of me that in retrospect thinks that this question should not have been that difficult for me. I don't just have major depressive disorder, I have panic disorder, I have chronic anxiety, I have OCD, I have insomnia. It is a long list. And even though I've always kept on trucking through whatever had to be done at work and at home, and even though I'm no longer sort of on the edge in the ways that I once was, if I'm honest with myself, it continues to have significant impacts on almost every part of my life. But there was a part of me that felt, and that to some extent continues to feel, profoundly uncomfortable with the idea of claiming a disability identity. That felt like I wasn't disabled enough because I don't experience access barriers, because I have never claimed an accommodation, even though perhaps there are times I should have. And because most fundamentally, I have the privilege of moving through the world without experiencing the type of everyday stigmatization that people with visible disabilities often confront. It would be nice if I could tell you that there was some sort of cinematic moment where all of this fell away and I joyfully embraced my disability identity. But of course, it was not like that. Rather, it has been many, many small moments that collectively have solidified this as an identity, including most especially many small moments in identifying myself as a person with a disability to others. This talk here today, which is the first public talk I have given, sharing the details of my mental health, is another step on that journey. So too, my insecurities about claiming a disability identity did not just fall away at some point, but they are today, for a number of reasons, a smaller voice in my head. First, at some point along the way, I was hit by the completely obvious, but to me, until the moment it occurred to me, completely invisible insight that I can choose how and where to deploy my disability identity. And that means I can use it to create space for disability liberation, but not to claim benefits or to co-opt conversations or to take up space that is not mine. So I do not have to identify as disabled, and I don't, for affirmative action purposes, or to try to get an edge in law review submissions, or to claim benefits set aside for those with access needs. I don't have to, and I don't center my voice or experience in conversations about disability accessibility or discrimination in the workplace, or any of the other many experiences of disability that I personally have not meaningfully experienced. At the same time, I do identify myself as a person with a disability where it will help to disrupt stigma or to build community. So as happened recently, when a relative responds to my discussion of disability mental health rights by saying that they too would rather hire the person without a mental health disability instead of the person with a mental health disability, I am able to point out that I am a person with a mental health disability and to call upon them to question whether they really think Rutgers would have done better to offer someone else the job 10 years ago. When my students in my disability law class, including those with their own brain or body difference, are struggling to identify the ways that disability can be a source of positivity or pride, or may have contributions to make to the legal profession, I can seed the conversation with my own experiences and then watch my students begin to think about for themselves all of the ways that their own disabilities have given them strengths and benefits and may bring important contributions to the profession of law. And I can, and I do now introduce myself on the first day of class in every class, even the really big ones, not only by stating my background as an LGBTQ rights lawyer and somebody who loves backpacking, but also by self-identifying as a person with a mental health disability. And that leads me to the final thing that has chipped away over time at the fear I have of co-opting disability identity, which is the ability to see how it matters to other people that I claim disability as an identity. So every single time I have identified myself as a person with a disability to a class, I have had numerous students reach out afterwards. To be clear, this is a passing reference in my introduction. I don't talk about it at length. I don't share the type of details I've shared here today. And yet every single time, numerous students come to talk to me about what an impact it had for them to hear me identify myself in that way. Most of the students who come to speak with me are students with brain or body difference themselves. Many of them enter law school feeling isolated and alone. Many of them are struggling with the same set of self-identification issues that I have talked about here today. And almost all of them continue to grapple throughout their time in law school with fears about a profession that purports to value diversity, while at the same time sending a million signals, small and large, that people with brain and body difference are not welcome. To be clear, I have always been an advocate for students with disabilities, even before I identified in that way myself. But as a publicly identified person with a disability, I have many, many more opportunities for students to find me and to be able to recognize without effort that we are on the same team. At the end of the day, there is, of course, also something very different about having a we conversation as part of the same community and having a you conversation as an ally. So let me conclude where I began, which is with a few final thoughts about how all of this relates back to the subject of our conversation today. The benefits, the drawbacks, and in this case, I would say the complicated nature of the disability frame. The disability frame has, I think, offered great power and potential to the disability civil rights movement by forging together the many different strands of brain and body difference into a unified whole. But it is also true that the disability frame in civil rights will only ever be as powerful as the collection of individual decisions to embrace it or to push it away. Movements are only as strong as their members, and in this case, many of the movement's members have opted out. But to be clear, I view this as a hopeful story, not of how we've been held back, but of how much further we can go as a movement when those of us who are part of the community recognize our stake in disability rights. And I see signs of people waking up to this all around, in the explosion of disabled law students associations, in the activism of so many amazing disabled people on Twitter, in the conversations going on among everyday people about whether to self-identify as disabled, conversations which, to be clear, extend far beyond the law. So I'm really excited to see where this journey will take us, and I look forward to being in conversation with all of you. At this point, I am going to turn things over to Professor Jamelia Morgan, one of my personal favorite disability law scholars, to hear her talk about her work.
Thank you so much, Professor Eyer, and just thank you for your generosity and your support of me as not only a scholar, but the incredible just inspiration you are to so many of us in the legal field. Thank you for sharing with us. My name is Jamelia Morgan. I'm a Black woman. I'm wearing my favorite blazer. I don't even know what color it is. I guess it's like a pink and a black shirt underneath. I have my hair braided in 2 large braids. I'm excited to be here to be in discussion with so many scholars that I respect and organizers who I admire, who have taught me disability rights and disability justice. Many of you will be on the panels for today. I use she, her pronouns. I also want to extend a special thanks to Professor Harris and Tani and for their vision for this event. I want to thank the law student organizers, Matt Seelig, and the incredible work that's gone into such a terrific set of conversations. I'm going to talk about the disability frame within the context of prison reform litigation. And I do note that the discussion is difficult. So I do say, issue a trigger warning before talking about some of the information that I'm going to share today. But in any event, I think it's important to kind of center the unique harms that we see impacting disabled people in our carceral spaces. Okay. So within the last decade, there has been an uptick in scholarship addressing the various forms of discrimination, including physical, mental, and emotional harms experienced by disabled people in prisons and jails. I see this recent literature as situated among a larger and more well-known critique of mass incarceration within social movements that have, until recently, focused primarily on race and class disparities at various stages in the criminal legal process, from arrest to conviction to sentencing, and then, of course, imprisonment. Expanding these discussions and critiques by addressing disability and processes of disablement within this ongoing social movement against mass incarceration and mass criminalization is timely and important for what I see to be 2 primary reasons. So first, disabled people are overrepresented in prisons and jails, and second, confinement in prisons and jails poses specific physical, psychological, emotional, and habilitative harms to disabled people in particular. So first, as to the disparities, You may all be familiar with the fact that people with disabilities are overrepresented in prisons and jails. The most recent national study by the Department of Justice's Bureau of Justice Statistics found that 26% of incarcerated people report having a disability. Depending on the facility and the definition, approximately 4 to 10% of respondents report having an intellectual disability. Over half of the incarcerated people reported symptoms that meet the criteria for various psychiatric disabilities. And finally, 40% of prisoners reported a chronic medical condition: diabetes, cancer, heart disease, high blood pressure, etc. So onto the harms. Disabled people are particularly vulnerable to the violence that characterizes much of our carceral spaces, many of our carceral spaces, I should say, as well as physical and psychological harms that stem from imprisonment itself. So prisons and jails are violent and dangerous places and produce severe harms to physical, mental, and emotional health and well-being. Now, these harms, of course, impact all incarcerated people, but in particular, I think we have to identify the unique harms and injuries that disabled people face. They face a heightened risk of violence, deprivation, and discrimination. Incarcerated people with disabilities are at greater risk for encountering violence while in prison and suffering injuries from these violent encounters. They face an increased risk of being denied access to appropriate mental health and medical services, along with therapeutic supports, putting them at greater risk of mental deterioration and declining health outcomes. Beyond this, there's widespread discrimination experienced by disabled people, and it takes many forms, ranging from a denial of access to medical services, educational opportunities, and rehabilitative programming. And also, I think importantly, segregation and solitary confinement, a behavioral management tool used across the country, which includes isolation in cells and conditions amounting to extreme deprivations of social and environmental stimuli for more than 22 hours per day. So many of us have been litigating on behalf of disabled people to challenge the violence and the harms that are experienced in prisons and jails. And I think in many ways, in light of these harms, it's perhaps not surprising that advocates have framed these harsh carceral conditions, whether it's the low quality medical and mental health care, the pervasive violence within prisons and jails, the poor nutrition, the decrepit facilities, and other harsh conditions, as disabling or debilitating, in that the conditions of confinement have produced or risk producing mental and physical debility. Advocates have relied on disability frames in part in order to capture the debilitating nature of the injuries and the scope of the harms, and to seek legal relief for their clients using federal disability laws. I think this points directly to what Professor Carey explained earlier. The disability frame refers to the characterization, as Professor Tani put it, of a particular set of problems about disability, and thus responses to those problems are identified as involving and inviting solutions using disability laws, to paraphrase. Advocates have relied on disability frames in part to allege legal injuries, namely violations of statutory and constitutional rights stemming from the physical and psychological harms, violence, and deprivation that disabled people experience in prisons and jails. So I've identified that disability frames are used in prison litigation. And one thing I think comes from this use are a set of questions. So though the disability frame might serve productive purposes, not all uses of the disability frame are beneficial. I think many of us in practice identified that there were ways in which characterizing a set of injuries as debilitating could also further the stigma of that we see prevalent in society against people with disabilities and the claiming of disability, to Professor Eyer's earlier points. So,
excuse me, Professor Morgan, would you be able to slow down just a touch?
Yes,
we want to make sure that we can keep up with the, thank you.
Apologies. In this presentation, I'm going to discuss some of the uses of disability frames in conditions of confinement litigation, including what I term stigmatizing disability frames and productive disability frames. Then I think we'll probably have time in Q&A to discuss productive and stigmatizing frames in relation to the goals of disability rights and disability justice movements. Okay, So plaintiffs have deployed disability frames to allege that prison and jail conditions are debilitating. There are two primary versions of the disability frame that I've identified. So in the first type of disability frame, plaintiffs argue that confinement in the harsh conditions of prisons and jails poses a risk to the incarcerated person's health or safety by making it likely that their physical and mental health will further deteriorate while incarcerated. The risk of or actual deterioration is due in part to the failure of prisons and jails to meet the medical and mental health needs of incarcerated people with disabilities, or the failure of prisons and jails to protect the incarcerated plaintiffs from harm, like violent assaults. So I find that where disability frames are used here, they are used to describe the nature of the alleged injury, constitutional deprivation, or denial of access. So let's take an example. Take the case Toussaint versus McCarthy. There, plaintiffs, incarcerated people in California jails, brought this class action lawsuit to challenge the conditions of their confinement in solitary confinement. They made specific allegations that the following conditions violated the Constitution. So segregation, heating and ventilation issues, plumbing, fire safety issues, hygiene, sanitation, denials of access to healthcare, violence, and overcrowding. So in reviewing the plaintiff's claims, the court noted that, and I'm quoting, the confinement to which segregating inmates are normally subject, locked inside a cell less than 50 square feet in dimension, allows very little meaningful exercise and is physically debilitating. With regard to the claim of a lack of adequate lighting, the court found there to be the physically and mentally debilitating effects, and I'm quoting again, of inadequate lighting. The court also noted that constant exposure to an intolerable level of noise, quote, contributes to the creation of a total environment where debilitation is inevitable. So again, we can see the disability frame surfaced in the court's description and in the plaintiff's framing of the harms while incarcerated. Now, there's a second type of disability frame that we see prison advocates use. Now, this is a disability frame that alleges that the ability of incarcerated people to rehabilitate is what is impeded. So access to rehabilitative, religious, or vocational programs. That is to say that disability frames are deployed to frame denials of access to rehabilitative programs, appropriate medical and mental health treatment as disability discrimination. When used in this way, the disability frame emphasizes not just that disability discrimination based on denials or disability discrimination is based on denials of reasonable accommodation, but also how such denials can impede the allegedly rehabilitative effects of access to programs that permit incarcerated people to develop educational, rehabilitative, and vocational skills. So here again, the disability frame is used to identify failures to accommodate and also disabling prison conditions that prevent disabled people from acquiring access to vocational, educational, and rehabilitative skills. Okay, so we're seeing prisoner rights advocates deploying disability frames strategically in pleadings, motions, and briefs. What do we make of the sort of use of these frames? Can we see them as productive or stigmatizing? So in my work, I've tried to think through the ways that we can identify the harms of incarceration, the violence of incarceration, in a manner that centers disability, yet doesn't stigmatize disability. And so in many ways, I'm informed by the incredible scholarship and activism of folks in the disability rights and disability justice movement. So I'm going to note a couple ways of thinking about what we can consider to be stigmatizing disability frames in the context of prison reform litigation, and how we can contrast that with productive disability frames. Okay, so a disability frame is a tool, as I've said, that can either maintain, entrench, or alleviate disability subordination. So let's look at what could be termed a stigmatizing disability frame. So stigmatizing disability frames use language that reinforce ableist or negative notions of disability. Ableist language remains pervasive in society, and it is one of the mediums through which stigmatized understandings of disability are widely disseminated. Ableist language, albeit likely unintentionally, does creep into prison condition of confinement litigation that deploy the disability frame, even on behalf of their incarcerated clients with disabilities. Again, this shouldn't be interpreted as a call out, but rather a call in for us to think through as advocates our use of the frame. So my reference to ableist language might call to mind the incredible work of Lydia X.Z. Brown, who provides a list of common terms that reinforce ableism. Phrases and pleadings describing disabled people as quote unquote suffering from disabilities are common uses of stigmatizing disability frames. As Brown explains, often ableism, often this language is ableist because it assumes that being disabled always means suffering, when that is frequently not true. Brown is quick to note, however, that if these descriptions are driven by our clients' own understandings, such language isn't necessarily ableist if it is, and I'm quoting, describing a specific, universally unwanted and painful experience, like having seizures, if it's coming from our clients. It is not necessarily ableist. But these distinctions in language matter and should matter to prisoner rights advocates seeking to avoid stigmatizing uses of disability frames through their language. Second, stigmatizing disability frames reinforce long-standing stereotypes that link people with treated and untreated psychiatric disabilities with danger, violence, and criminality. We can imagine these concerns to be heightened in a carceral space where those stereotypes and norms, and indeed the alleged basis for the person being there in the first place, is an act that society has labeled as criminal. In court opinions and briefs challenging harmful practices like solitary confinement, stereotypes that link disability with dangerousness and criminality can creep into advocacy, even when we think that the advocacy, or indeed when the advocacy is on behalf of incarcerated clients with disability. I use examples in my work, again, not to call out any particular attorney, and so I modified the facts so as to not isolate any individual actor, but I can provide an individual example to give you all a sense of what I mean. Okay, so the following is an example of how stigmatizing disability frames show up in pleadings and briefings, and may reinforce entrenched stereotypes that link psychiatric disabilities, particularly untreated psychiatric disabilities, with tropes and stereotypes of danger, violence, and criminality. All right, so I've modified the name, but largely the words remain the same taken from the pleading. Jack was not able to maintain good behavior while in prison. Jack suffers from schizophrenia, among other mental illnesses. Jack's mental illness showed up in prison, and Jack decompensated in prison. The illness causes Jack to act irrationally and to break prison rules, including rules against self-harm and staff assault. Jack received disciplinary tickets for these rule violations. As a result of these violations, Jack lost good time. So the above account starts with the deficiency framing. Jack is not able to maintain good behavior, and disability is the implied cause for such deficiency. What is expressly stated is that Jack's disability causes him to act irrationally and violently. Yet what may be implied is that Jack's disability is exacerbated by the prison's failures to provide him with adequate mental health treatment, or by the harsh conditions of imprisonment itself. These structural problems can be implied from the legal remedies sought, and indeed this was a case bringing ADA, or Americans with Disabilities Act, claims. But in establishing the seriousness of the injury, what we see here is the risk that negative views of disability might seep into the advocacy. And so I'm happy to talk through in Q&A the tensions between developing a set of facts to meet the legal standard and doing so in a way that doesn't focus in on a deficiency or negative view of disability, but focuses in on the structural harms that might be producing the injuries that are alleged. Lastly, I'll talk about what I identify as the third disability frame that might be stigmatizing. And I'm relying on work by two terrific disability law scholars in our community here. So Duran Dorfman refers to special rights discourses in his work, and Nicole Porter refers to special treatment stigma, both of which might promote, or do indeed promote, stigma against disabled people. I'm applying these frameworks into the context of prisons and jails, and using it as a basis to understand prisoner rights litigation. So according to Professor Dorfman, special rights discourses maintain that, quote, minority groups gain an unfair advantage by disguising their demands as striving to achieve equal rights and an even playing field when they are actively seeking extra benefits. According to Nicole Porter, special treatment stigma occurs when employers are willing to hire or promote employees who need special benefits or accommodations in the workplace because of the real or perceived cost of providing such accommodations. So one of the things that I note is that disability frames might further these special rights discourses and special treatment stigma in cases where advocates frame plaintiffs' requests for relief as quote unquote special needs. So here again, the cases often frame plaintiffs' legal injuries as the result of individual deficiencies rather than structural ones. Special needs framing may obscure or diminish the universal harms that characterize much of prison life and that affect all incarcerated people. But furthermore, within carceral spaces, such framing may produce heightened vulnerabilities for incarcerated people who claim disabilities, to again refer back to Professor Eyer's work, reinforcing pre-existing hostilities among incarcerated people or between staff and incarcerated people, along with other vulnerabilities. So there should be, I guess, at this point, some real caution in deploying, or at least thought behind deploying disability frames, care in doing so in the kind of prison condition, carceral context, given the risk of these stigmatizing frames showing up in the advocacy. I do also talk about the productive use of disability frames, the ways that disability frames provides a means for identifying not only individual harms of mass incarceration, which are of course important, but the structural critique of carceral conditions and the impact of those conditions on people with disabilities in particular, and all incarcerated people more broadly. So the frame facilitates an examination of the conditions of prison or jail and how those prison conditions produce disablement and are in a large part produced by the policies and practices that dictate how prisons will be managed. I think that this focus in on the harm to bodies and minds, or as we say in disability scholarship, body minds, are really important injuries to center. And I think that in many ways they can inform the potential remedies that are sought and ensure that we have inclusive remedies. I think also the disability frame in terms of productive uses might be more attuned to the literal physical, psychological, and emotional harms. I think that in many ways, the disability frame can be used to kind of uncover the oft overlooked unique harms that are produced by system-wide security policies rooted in a command and control, one-size-fits-all prison governance model. So we can think about how disability frames can be used to disrupt universal strip search policies, where all incarcerated people are subjected to invasive pat downs and frisks. In some cases, they can be visual. In other cases, they are physical pat downs, even when they're attempting to access things like therapeutic services, even when they perhaps are survivors of sexual assault and violence. And so a disability frame centering in on the unique vulnerabilities of individuals with PTSD, of survivors of assaults, can be used to disrupt these command and control infrastructures and models that characterize prison governance. So there's a lot more to say, to think about the stigmatizing uses, the productive uses. As I said in my opening remarks, I would love to discuss in Q&A, if there's time, how disability frames can further the specific goals and the different goals of disability rights and disability justice movements, and particularly the different and separate goals of prison reform, decarceration, and abolition, because I do see obviously differences in the use of both stigmatizing and productive frames across those areas of advocacy. So happy to discuss more, and thank you all for your time and attention.
This is Conor Dwyer Reynolds. I'm wearing a light gray jacket with a black shirt. I have large gold rim glasses on, a almost bald head, and a large mustache beneath my nose. I use he, him pronouns, and I'm extremely honored and excited to be here. As a person with a disability, it's so amazing to be in spaces where we are talking openly and progressively about this kind of identity. I'm honored to be serving on this panel with Professor Eyer, who I so deeply respect as a queer person in the United States, for all of the work you've done. I'm also the executive director of Rochester's Police Accountability Board, so I'm honored to be here with Professor Morgan, whose article, Rethinking Disorderly Conduct, I assigned to my staff because of its amazing insights on the realities of a very commonly used statute to discriminate against ordinary people. I want to thank, as everyone else has, the amazing student organizers of this. Matthew, his persistence in getting this thing done. I just want to appreciate their work so much. Obviously to Professor Harris and Professor Tani, in particular, Karen Tani has just been such a phenomenal mentor, advocate, and friend of mine. And to be invited to be a part of this thing is just amazing. So I want to start by hopefully connecting I won't call it a piece, I'll call it a provocation to myself and my personal life, because I don't think it's possible to fully understand our academic work without understanding our personal work. So I grew up in a family with every person having a disability and no one knowing it. Obviously, we often talk about invisible, quote unquote, disabilities, a categorization I'm not particularly a fan of, but I'll use it here for illuminating certain purposes. You know, my father has type 1 diabetes. My mother has major depressive disorder. My sister has bipolar disorder, and I have bipolar disorder and PTSD. And yet, throughout our life, none of us ever talked about the word disability. It was never used in our household at all. And despite this fact, these disabilities led to extreme economic difficulty. You know, many of my family members grew up on SSDI, faced discrimination in the workplace, faced discrimination in their communities. and they had no conception of why. And the irony is that so much of my family, including myself, came out, through my lifetime and found the liberation of the queer identity as something that changed our lives forever. And so I like to say sometimes that I came out twice, once at 22 as a queer person and as a bisexual man, and then at 27 as a person with bipolar. And these were things that I'd had my whole life. But when I talk about coming out, I think about the costs of having not done so for myself and the people in my life. Not even knowing that the Americans with Disabilities Act was something that anyone in my family could access. I think about all the different times in which my parents lost jobs, in which my family members failed to receive the support they deserved, including myself. And when I began law school, when I was in my early 20s, was the first time that I actually came into contact with the ADA. And it was life-changing. I remember going back home and after my first year in law school and coming to a place where one of my family members had just been released from long-time psych care and talking about an impairment in their brain, and that the issue is that the world around them was causing them their inability to stay in a position. And I remember crying with them, thinking about that. And so the power, all that's to say is that I think I know personally, as so many people in this, watching this do, the power of correct framing. The power of correct framing to change our lives, and the power of correct framing to change our abilities to work together towards collective change. And so I bring that all as a background to what a place in the law where the absence of an appropriate framing is potentially holding back what Shirley Lynn might call a collective approach to changing the way we think about disability rights. So just one more piece of background before we dive into the substance. So when I began teaching law, I was initially doing environmental law. And when I started, I taught a black letter environmental law class from a different perspective, where we taught the Americans with Disabilities Act as an environmental statute. And again, that was a bit of a provocation. And part of that was because as I started practicing and teaching environmental law, this was after I had come into the world of disability law and recognizing my own identity as a person with a disability. And it was shocking in a set of law where we constantly think about environmental problems, thinking about collective solutions, et cetera. There was almost no overlap or intersection with the social model of disability. The idea that it is our environment around us that causes the harms that people with disabilities face, rather than something being within ourselves. And so it was kind of shocking that the primary way in which people talked about, and at least oftentimes in environmental law spheres, people talk about disability is in the context of things like plastic straws and plastic straw bans, in which environmentalist communities are seen at odds with people with disabilities and disability rights communities, and that the intersection is one of conflict that has to be negotiated, rather than there being disabled voices within environmental law spaces. And so the initial provocation from my end was to have environmentalists and environmental law students see the Americans with Disabilities Act as a tool that is an environmental statute, in the sense that there's no more powerful law perhaps in shaping the built environment inside urban areas. And so seeing curb cuts and laws that structure that as just as important about laws that structure clean air in our cities, and seeing the importance of seeing disability law as a tool for environmental justice might allow people who otherwise might not have any familiarity with disability law to start understanding its framework and recognizing its power. But the flip side of bringing these two seemingly different parts of law together is taking a disability law and disability rights framework and applying it in the environmental context. And perhaps the easiest way to see this is through the lens of asthma. And I'll explain why this is important in just a second. But I have to mention this because I know Professor Dorfman is on the call. When I was clerking and working on the federal judiciary, I had the amazing honor of being able to work for the Honorable Carlton Wayne Reeves. Some of you who may know for his opinion in Boatner v. Berryhill. Judge Reeves is amazing for many reasons, but one of the reasons is that he hires clerks who come from different backgrounds, specifically work on different kinds of work. And so I was able to spend a great deal of my clerkship working on SSDI appeals. And being able to work on those appeals as a person with a disability was powerful. Nothing brings home the truth more that we need, nothing about us without us is the absolute truth than being able to shape and write law for people like you. And so Boatner v. Berryhill is something that Professor Dorfman contributed to in very significant ways through their research and scholarship. And so coming out of that context and dealing with SSDI appeals in the context of disability, when I came to teaching and writing, made me think about the broader structure of air quality law and the way that environmental law deals with what is a disability, asthma. And so now to the provocation rather than the background. When we think about environmental law, we rarely think about disability law. And when we practice Clean Air Act law as environmental lawyers, there is so much within that law that is about clean air, clean water, things that affect the world of health and disability. But when we think about the effects of the Clean Air Act, we often think about them in the terms of health law and the way that clean air prevents disabling conditions. And so when we do things like cost-benefit analysis in the context of setting air quality standards, we entirely categorize disabilities as costs. So that is one very important way to see that the framework within environmental law may not be the one that is adopted by disability rights advocates. But part of what my argument is that there is a hidden regulatory framework for disability itself that is not within this framework of preventing impairment, but instead regulating environments that make conditions disabling. And as you can see this through asthma. So sometimes it can be hard to see asthma as a condition that actually is a disability, but the fact is that the asthma is the most prevalent disability for children in the United States. It's also a very common disability that comes up in the context of both ADA litigation in the employment context and SSDI appeals. Asthma attacks can be exceptionally limiting for people's lives and work. If you have asthma as an adult, so much of your life can be ordered around looking at the air quality index where you live to determine where you can go on a given day. Asthma is one of the best ways to actually visualize the disability, the social model of disability, by showing how the environment around people literally prevents them from walking and working and living in certain places. Asthma often becomes disabling, though, only in places where certain triggers are present. And chief among these triggers are air pollutants like nitrogen oxides, which can make entire neighborhoods, cities, or metropolitan areas disabling, dangerous, and off limits for people with asthma. Now, if you actually go to the federal government and look at asthma and who regulates it most, you might think it's in the NIH. But in fact, most of the federal government's work on asthma regulation response comes through the Environmental Protection Agency. And the Environmental Protection Agency regulates asthma primarily through its work in the Clean Air Act. And I'm not going to describe in depth the regulatory framework of the Clean Air Act. It's not exceptionally important for the purpose of this conversation. What you need to know is that the Clean Air Act regulates asthma attack-inducing pollutants through the National Ambient Air Quality Standards, which define how much of a key trigger pollutant may be present in various regions across the United States. Federal standard setting on these pollutants happens on a periodic basis every few years. The current process is just wrapping up at the federal level. These standards, these air quality standards, are based on how different levels of pollutants will affect, quote, sensitive populations. That is how people with disabilities are referred to in all of the rules, regulations, and the enabling statute when it comes to clean air regulation through these national ambient air quality standards. There's never a mention of the word disability or disabled in all of the cost benefit documents and scientific analyses that go into setting these national ambient air quality standards. When you look at the scientific panels that advise the Environmental Protection Agency on how to set these standards in a given region in the United States, the Clean Air Scientific Advisory Committee, that's a subcommittee of EPA's Science Advisory Board, there's no legal mandate that anyone on that committee be from the disability community or be a directly impacted or affected person by any of the air pollutants. The EPA scientific staff, which comes up with the initial integrated scientific assessment to set the boundaries of the deliberation of EPA policy officials around what the eventual standard should be. There's no requirement that the staffers doing that work be from the disability community. And there is no requirement that these scientific advisors or the policymakers take into account the fact that disability may be less or maybe more than just a cost. And so what I'm saying is that entirely missing from this framework of regulating the environment that makes asthma into a disabling condition is any sense of the people who are affected directly by it. Instead, the Environmental Protection Agency takes a purely medical model approach to understanding asthma as a disability. And you can see how this harms people with asthma. So when you go to the EPA and they say how people should respond to the condition of asthma, the primary response is through education around how individuals can take individual action to prevent asthma attacks. This is by monitoring AQI. This is by carrying inhalers. This is by not going to certain places during different parts of the day and teaching your children who have asthma to take it upon themselves to do these kind of day-to-day calculations. The parallel here is obviously with people with type 1 diabetes who have to constantly be the burden, and what the government tells people in the diabetes context is to monitor your own condition. Similarly with mental health disorders, to monitor your own condition, to take care of things on your own, and you are to be blamed if you miss a medication. You are to be blamed if you aren't happening to be in an environment where you have access to insulin. So the EPA's approach to regulating disability is not just adopting an individualizing framework through the regulation of asthma at the standard setting level, but also through the way that the agency publicly talks about asthma. And the way that the agency talks about asthma encourages people to see it both through the medical model of disability and to see it as an individual problem that needs to be assessed through individual action rather than collective action. So, how does this all tie together? Well, from the perspective of the disability rights movement, and I want to again quote Shirley Lynn's Bargaining for Integration article here, which identifies how individualist ideologies reflected in canonical disability statutes prevent people from disabilities from restructuring exclusionary environments through collective action. There is, within this framework of the Environmental Protection Agency's regulation of air pollutants that affect asthma, a collective framework for addressing these problems. You can imagine a world in which, like there is the access board to deal with the regulation of public buildings in the context of accommodations and access. You could imagine these kind of disability rights law approaches coming into the Clean Air Act context and allowing people with disabilities to directly regulate on a collective level the impairments and the environments that affect those impairments. And the issue is that until the environmental community and environmental law is invaded or dominated or taken over by people with disabilities, that avenue of collective regulation and response to disability will not be available. And so I wrap by saying this, the provocation here is to crip the Clean Air Act. And we can do so by taking what we might think are somewhat outdated models from the past about things like the Access Board, revising cost-benefit formulas through things like negotiated rulemaking to reflect the full costs and benefits of disability, and building on DOJ positions that were outlined in cases like Save Our Summers, to bring those places where we've seen so much advance in the disability law sphere and bring it into the environmental law sphere to see collective action that's so desperately needed. And so I'm going to end my talk there because I'm so excited to hear more from Professor Eyer, Professor Morgan, and from the commenters. So thank you all for taking a listen.
Apologies for the interruption. This is Matthew. Let me pop in because it is time for our middle CELI code. But I do want to take a moment to just thank our panelists for slowing down so that we can all engage with their profoundly powerful remarks. Ashlyn, could you give us the announcement?
Yes, hi again. Again, if you're seeking CLE credit for today's event, please note the CLE passwords will be announced twice per hour. Again, please write down this password and enter all 3 passwords for this panel on your digital evaluation form once the event is over. The evaluation form is mandatory to receive CLE credits. The link to the evaluation form was emailed to you in your event reminder email, but again, I will put it down in the chat below for you to have it. These passwords will tell us how long you attended. So the second password for this panel is CAKE, C-A-K-E, CAKE. Thank you.
Hi, I'm Shaun Ossei-Owusu. I'm an African-American man with black hair, brown eyes. I'm wearing a light brown turtleneck and a brown blazer, and I have a baby afro. I use the he, him pronouns. My background is blurred, but I'm in my home office with a bookshelf, a television, and a picture of the late, great W.E.B. Du Bois. So I want to start off by thanking all the members of the Law Review, of DALSA, and all the students who helped put this larger convening together, all the people who are helping to make the event more accessible, Professor Tani and Professor Harris, as well as the panelists and audience members for their intellectual company this weekend. I'm teaching a statutory anti-discrimination law course this semester where we spend weeks discussing the ADA, IDEA, FHA, Section 504 of the Rehabilitation Act, Section 1557 of the ACA, and other statutes that prohibit discrimination based on disability as well as other categories. And I assigned the work of some of the people who have or will present during the conference. So again, I'm really enjoying the intellectual company this weekend. I'm going to start off by summarizing the paper/presentations and offer some reactions, comments, questions of curiosity, and everything in between. And so some of these questions are about disability law and justice more generally, and some are about the specific theme of the disability frame. And I don't imagine that all of them can be attended to, but wanted to just raise them, and the panelists can elect to answer whichever they feel are appropriate. And then we can move to some of the questions that have been raised by audience members. Professor Eyer's work provides a deeply personal set of accounts on her journey of identifying as someone with a disability and its relationship to legal education in our broader social world. In reading her work and hearing her talk, a few questions came to mind. And so I'll say Professor Eyer came to a class that I taught with Professor Tani last year, as did Professor Harris, and they were 2 of the favorites, so I'm happy to gauge her work again. And so Professor Aya helpfully captures how students with disabilities may feel unwelcome. And the first question, which is seemingly general and simple, is how do law professors and administrators make them feel more welcome? So there are some obviously readily available answers tied to accommodations, what we decide to cover in class, e.g., bringing in discussions of disability in traditional doctrinal courses where relevant, even if they go undiscussed in the doctrine or the casebooks. There's engagement with student groups. And as discussed in her Journal of Legal Education article that I hope you all read, certain versions of allyship and self identification, specifically for people who might be ambiguously disabled and fall betwixt and between different definitions of disability. So, this first general question is what else can law professors do? Another question, which is arguably more technical and legal, but potentially fruitful, is where temporary disability fits into this helpful analysis. And this again can be in a strict legal sense, so under the ADA Amendments Act, um, in a social welfare sense, or more generally. So the most common example tends to be temporary conditions tied to pregnancy, but there's also a pandemic that is helping people think differently about health conditions and complications. So how do we think about temporary disability fitting into the encouragement for law professors to identify? And how might we think about this in the context of your important observation, which has been echoed by other disability rights scholars and advocates, that claiming disability does not mean a windfall of resources on one hand, and a concern about co-optation and inappropriate claiming of space on the other hand. Professor Morgan's paper focuses on the disability frame in the criminal justice system, and it's always a privilege to read and learn from her work. So she shows how, in accordance with the theme of the conference, it's a choice that's used by disability and criminal justice advocates. Professor Morgan notes how there are unique harms that prisoners with disabilities face that span the physical and psychological gamut. She notes that it can be productive and stigmatizing, in one context highlighting the structural problematics of the criminal justice system that impacts everyone, but in another sense in ways that reinforce ideas about disability that frustrate movement goals, move the disability justice movement as well as abolitionist movements. And so many questions came up as I read her paper and heard her talk and thought about it vis-a-vis some of the other papers. So my first question, which is tied to an issue mentioned in Professor Reynolds' paper, is about the role of experts. So I suspect that many of the people making the decisions about what happens inside correctional facilities, about many of the people who are making these decisions in correctional facilities, so think correctional officers, parole boards, and other bureaucrats. I suspect that they're certainly not experts on issues of disability, although it would be interesting to know whether they have or identify with the disability identity. But the question here is, how do we get more experts in the room? So this is less focused on traditional advocates, so lawyers for prisoners, but bureaucrats. Is such a project worthwhile considering abolitionist goals? Or is this a kind of reformist reform that's similar to calls that say, let's get more Black officers on the street in ways that don't address real problems? I suspect that it might be different, and certainly not in service of the end goals of abolition, but might shape the experiences of prisoners in the interim, and those who identify with having disabilities as well as those who do not. My second question is somewhat related and tied to an important point you make in your paper about how the disability frame can help challenge and undermine the legitimacy of blanket policies that fail to take into consideration the unique needs of incarcerated people with disabilities. And so Professor Morgan knows how these things how the frame can help educate and persuade courts around the material harms of incarceration. And so my question here is, how do we as scholars, advocates, and allies begin this work earlier so that attorneys, clerks, and judges are already coming into these spaces with a more robust understanding of disability and the criminal justice system, and not at the point of litigation? And so the working answer here might be tied to how we teach criminal justice courses, questions around training. But as someone who works more deeply in these areas, I wanted to invite you to chat a little bit more about the possibilities of productively deploying the disability frame to educate penal bureaucrats much more earlier. Professor Reynolds' paper focuses on the underexamined relationship between environmental law and disability justice, and it was helpful to think more deliberately about this intersection. Focusing specifically on asthma and the Clean Air Act, Professor Conor argues that asthma-related disability could provide an alternative to the individualistic regulation that has been criticized by activists and scholars. So the act itself vests power in the federal government and an expert class to regulate and investigate disabling environments, notwithstanding that authorities conflict with the disability rights movement's mantra of nothing about us without us. Professor Reynolds provides a variety of suggestions that might give people in the disability rights movement more regulatory power, and I had a few questions here. My first question is tied to a point made in Professor Eyer's paper and in the disability law world more generally about resources and co-optation. And so here I'm thinking about asthma. So I, along with Professor Harris, are from the Bronx. And there are a few neighborhoods where asthma is an acute problem. In one neighborhood, Mott Haven, which is in the southernmost point of the borough near Manhattan, residents need asthma hospitalizations at 5 times the national average and at rates 21 times higher than other New York City neighborhoods. This is also a neighborhood that is quickly being gentrified by people who can't afford their brownstones in Harlem. And you can imagine a world where more attention is given to environmental justice in this neighborhood as the racial and class composition of the neighborhood changes. And so thinking about intersectionality, should we worry about a world where a new group of disability-informed experts are in the room but may not reflect the diversity of the disability rights movement? And so we've given regulatory power to disability advocates, but it's fractured by issues tied to race, class, sexual identity, orientation, and expression, as well as different types of disability, so brain and body difference. Is this an unfounded concern or a second order priority given the current unrepresentativeness in the environmental law regulatory regime, or is this the wrong way of thinking about the relationship between geography, environmental justice, and disability justice? My second question is tied to Professor Eyer and Professor Morgan's papers, as well as the theme of the conference. And so in advocating for this kind of regulatory power, and in a world where this is achieved, how do we avoid instances in the environmental law context where the disability frame is imagined as disempowering or stigmatizing, especially considering the unique harms of environmental justice and inequality? Put differently, how do we ensure that the disability frame used in the environmental regulatory context is empowering and reveals the structural dimensions of environmental injustice and regulation? So I'll pass the mic back on to you all. Hopefully you can respond in 3 to 5 minutes, at least some time for some of the great questions that have been raised in the chat, or you can opt to forfeit and we can get straight to some of the great questions that have been raised.
I mean, this is such a terrific and provocative set of questions. I'm going to respond just briefly to one of them because I do want to leave time for the chat. But I think having the captive audience, right, of how do we think about what law professors and administrators can do to make law students with disabilities feel welcome. This obviously is to some extent preaching to the choir. I'm guessing most of us on this call already think quite a lot about that. But I do think emphasizing that simply the list you laid out, if we could start there, right, and really not just do these things ourselves, but encourage our colleagues to really think about these issues and embrace them, we would be a long way from where we are now. I'm sorry, this is Katie Eyer speaking again. So thinking about even to the level of language that appears in cases, I often hear complaints from students that law professors reproduce offensive, antiquated language about disability. It's a super easy problem to solve by just observing that it's antiquated and offensive language about disability and substituting in other language. Attending to disability when it's the backdrop of cases, even when it's not explicitly stated as such in the curriculum. Professor Morgan has written wonderful work about the ways that disability lurks in the background of so much criminal procedure and Fourth Amendment decisions. Bringing that to the surface and really surfacing it, I think, is important to helping students with disabilities to see the care that's being taken with these issues. Accommodation, I would say further universal design, thinking about how to make classes accessible and encouraging colleagues to do the same from the front end without the need for a request for accommodation. And certainly I do think that the type of, for those of us who have invisible disabilities, thinking about whether there are ways we can productively self-identify, both to help break down stigma for students, but also to be able to provide the type of proactive mentorship that I think is really valuable. And then the last thing I'll say is that I think the rise of disabled law students associations is amazing. And if one single thing could transform the sort of experience of law schools for disabled law students, I think having a thriving DULSA at your institution is it. So I'll turn it over to Professor Morgan or to Professor Reynolds if they want to jump in on their terrific questions next.
I just want to quickly interject that Matt mentioned that we have a little wiggle room with time, so don't feel rushed in your answers.
So I just want to thank you, Professor Ossei-Owusu, for your incredible sort of summation and the provocative questions. And again, to my co-panelists, Professor Reynolds and Professor Eyer, because I find this just incredibly generative. So I'm going to tackle one aspect of the question that you posed regarding thinking through, how scholars, advocates, and allies can kind of facilitate a more robust understanding of disability and do so earlier in the process. And I think it ties in a question that we have in the chat regarding the role of advocate, right? Your audience is the judge and the jury. And in many ways, as I've shown in prior work, there might be a sort of incentive to lean into, again, unintentionally, to lean into ableism in order to establish the constitutional showing, let's say, for a serious medical need under the Eighth Amendment provisions, or to establish the seriousness of the injury, let's say. And so, that's a tension. And then the current state of the courts and juries in our general society with respect to ableism is also a tension. But when I think about the incredible work that disability rights activists and today disability justice advocates are doing to kind of push back on ableism, a lot of the work that they're doing is taking place in, folks have mentioned Twitter and our public sphere more broadly, to really identify and name ableism and to develop an analytic for understanding social problems. And so, I know many folks are on the panels today. Rebecca Coakley comes to mind, Talila Lewis, Dustin Gibson, Lydia X.C. Brown, Kathy Flattery, I see online as well. The analysis of disability rights and into disability justice allows us to examine social problems so we can see the disability elements of them. That's an analysis that's learned, it's not intuitive. And I think as lawyers, we can center in our advocacy, those educational aspects, right? Which is to say, in briefing, and I do some technical assistance and support for litigators around the country on some of this issue. And of course, in learning from them as well, even something like language, like we know language is power. It's not sort of tinkering at the edges. And so if there's a stigmatizing term that's being used in your pleadings, you can say, well, it's commonly known as this, we're going to use this term. And then I usually include a footnote. These are the reasons, right? We can think about the moment that we're in, where we've had federal laws that are changing the definition of mental, insert R word and slur, to intellectual disability, right? There's a kind of recognition, at least under the Obama administration, that language matters and that we should make a change to formally recognize the changes in norms around our language use. And that kind of leads me to this discussion of sort of prisons. I think when you start to think about disability critically, and a disability justice analysis leads you not to a project, and this is, I think, kind of tying up to the social movements aspect of my work. It doesn't lead you to a project that's necessarily satisfied with creating carceral prisons. Humanistic prisons, right? Kind of what is kind of turned carceral humanism, just drawing from Liat Ben-Moshe's work. It leads you to critically think about the ways in which policing is a site for the criminalization of disability and the disciplining of non-normativity as identified in some cases as disabilities, in other cases as things that need to be controlled and changed. And so I think what happens is you start to look at the prison as a site and a continuation of forms of disability-based subordination that we can see in the eugenics period, the period of forcible sterilization, and to push towards a future where there is certainly a reduced reliance on the prisons as this site for kind of disability disciplining, and to resist criminalization, to resist punishment systems. And I think in a way that kind of explains why disability justice movements have pushed disability rights into the direction of abolition. And so I think that if we think about kind of disability critically, and we're moving towards a future where we don't see these forms of policing and punishment of disabled people, if you accept the analytic, then I think that we also, we as, well, I guess I'll be clear, then I think prison litigation looks different, that it's about harm reduction and not the end goal of just accessible prisons, if you will.
This is Conor, Dwyer, Reynolds. I want to quickly address the question about race and environmental law, and then I want to turn to the question of bureaucracy. So the answer is, if the co-option of environmental law is not done by Black and brown disabled people, it's going to fail, period, for the exact reasons that you talked about. There's just no doubt about that. The whiteness of the much of the core and leadership of the disability rights community is probably to blame for a lot of the structural issues that we see in canonical disability civil rights movement statutes and advocacy. And so I don't know what more to say there, except that it's not surprising that asthma disproportionately affects Black and brown people, and it is so poorly regulated in the United States. For the bureaucracy point, I think it's just one that's on my mind a lot. This piece came to my mind as someone who's now a bureaucrat more than I am an educator. And I have the blessing of being able to build a bureaucracy from the ground up. I have hiring authority to build, carte blanche, new enabling statute, and 50 people to hire and fill it. And so much of our time is spent on rules and regulations. And I came into this position thinking that would be my primary way of shaping the agency's culture and work. And that's not true. It is staffing. It is who I put in the positions to do the work. And I think the best thing that bureaucracies can do is see lived experience as expertise, period. And that's actually somewhat hard to do, given what you can and can't ask about, right? Because no, it makes sense. Traditionally, bureaucrats, if you're Black, brown, disabled, that's going to be held against you. And figuring out ways in the current legal environment to see that as expertise that qualifies people. And it's obviously exceptionally important in the policing context, right? you can do all of the book learning you want, but a drop of lived experience of policing is worth more than an ounce of, book learning, right? And that's everything from fighting civil service, the minimum quals for civil service positions that think that a degree in criminal justice is anything equivalent to living in a police community. But it works in the disability context too. And what's very hard is that, and this gets to Professor Eyer's point, is that disclosing disability status in a cover letter and application, you're just begging to get discriminated against. I got to accommodate this person. It's awful, right? And so how do we create bureaucratic contexts through law and culture where this expertise is valued, protected, and seen as something that can be displayed? We're so far from that. And because we're so far from that, our bureaucracies are just so flawed. Those people doing the cost benefit analysis, the EPA, I don't have much, I can talk about provocation about how we can create new frameworks within an agency. I think it's ossified. I don't think you're ever going to get there. I really don't. But when we're talking about local agencies on things like policing, I have way more hope, way more hope because of size and the flexibility of agency creation at the local level. So hope and a kind of fear, but I'll end with that.
Okay, I think I'd like to at least try to get 3 of the questions that were raised in the audience and perhaps direct them toward some of the different panelists. So the first question for Professor Eyer, this is from Rosa Marie Thompson. Rosa Marie writes, many of these stories about identifying as disabled or coming into disability exist in the narrative. Oh, and I should say, this is Shaun Ossei-Owusu talking, sorry. But many of these stories about identifying as disabled or coming into disability exist in the narratives humanities component of critical disability studies. Could you say more about how these narratives of coming into identity might be effectively included in law school education? So that's for Professor Eyer. For Professor Morgan, and you were started toward this in your answer, and I might put it a different way, but Maria Shah, forgive me if I mispronounced that, writes, I totally resonate with the argument of employing language that is not ableist. However, as a litigating attorney, your case also rests on what the judge thinks and what the jury thinks, especially in criminal law matters. A lot of society, including judges and jury, grapple with these notions of disability we consider ableist. How do you balance the expectations of adjudicators and the need to be mindful of not perpetuating stigmas? And the question reminds me, and I'll put it in a different way, of this kind of debate between Tony Alfieri and Abby Smith as it relates to questions of race and advocacy. And so Professor Alfieri writes that lawyers should be conscious about perpetuating racial stigmas in their advocacy that might harm Black and Brown communities, whereas Professor Smith comes more from a PR perspective and suggests that you use whatever tool is at your disposal as an advocate, and if you don't do so, that might raise kind of questions about competency and effective assistance of counsel, etc. It's a really interesting debate, and she's bringing it also from a kind of a different racial justice perspective. And so one might think about that debate in the context of this question that's raised in terms of disability and reinforcing ideas about ableism. And so Professor Reynolds, M. McGar writes, Fair Housing Act regulations include the obligation of state, county, and city levels of government to affirmatively further fair housing. So this is the affirmatively fair housing rule, which includes undoing already existing segregation. It's well documented that people with disabilities are overrepresented in poor communities. So by allowing conditions that threaten the lives of people in poor communities that are in poor air quality areas, isn't the locality treating people sensitive to asthma differently based on where they live? And would that violate the affirmatively fair housing regulation? The analogy is the use of the civil rights laws to attack the lack of hospitals, hospital closings in poor communities, which result in death because it takes longer for an ambulance to reach help. So I see this as a kind of question about thinking about this intersection of environmental justice and disability justice, but through the lens of fair housing. So I'll pass the baton back to you all.
Thank you. This is Katie Eyer speaking again. And I have to say, I was really excited to see this question from Professor Garland Thompson show up in the chat, because Professor Garland Thompson, your work was one of the key bodies of work that I really was impacted by and thoroughly enjoyed reading, both in my academic work on this issue and in my own personal journey to disability identity. So I will say, yes, absolutely. I think there's been a lot more sort of work thinking about issues of disability identity and claiming disability identity that's gone on outside of the space of legal academia. And part of the project that I wanted to engage in the paper that the academic paper I ultimately published on this, was to bring that work into the legal academic domain and sort of call it to people's attention. So I have a lot of discussion of your work and others' work, as well as not just academic work, but also the various manifestations of this out in the world, because this is not just an academic movement. This is something that everyday people are thinking about and grappling with, and I think that that's really important. So how can we do more of that? In my disability law class, I assign work about individual narratives of journey to disability. And that's been part of a shift from just teaching the law to also recognizing it's important to think about ourselves as subjects of the law, and the fact that we often have many disabled people in the room for those conversations. I'll also say, though, ultimately, I view this as not really an academic project, but much more of a social movement project. I think that, what I would love to see is, and I know there's been work like this by activists using social media to really give people the opportunities to claim disability identity publicly. I'm blanking right now on the specific woman's name who I'm thinking of, but there's a woman who's done a wonderful set of campaigns on Twitter, show me what invisibly disabled looks like. And then we have these moments. And again, these are the moments that really count, I think, often for claiming these types of identities of, millions of people posting under the hashtag, this is what invisibly disabled looks like. So great question. I think it's a really valuable project to get those narratives out there more. And thank you for your work and for your question.
Great. This is Jamelia. I'll add just a couple quick reactions to the terrific question that was posed to me. So I think that there certainly is a way to zealously advocate for your client and do so in a way that's consistent with your ethical obligations as an attorney and not reinforce disability-based stigma and subordination. I think the details of that can be sorted out in each individual case. But I guess in many ways, I'm optimistic because I think that as attorneys, we have an obligation to resist erasures in the law that might underprotect the rights of vulnerable groups. We have an obligation to resist forms of resist areas of law and doctrine that kind of reify the erasure and exclusion of vulnerable groups. And so, for instance, in my work, I've shown if the Fourth Amendment underprotects the rights of disabled people, there's a way that through advocacy, attorneys can center disability as a lens and push back against that erasure and strengthen the privacy and security interests of disabled people, again, through law and as a harm reduction approach. And so when I think about, what the Eighth Amendment might require in terms of establishing serious need and serious injury and how that can kind of construct a disability as a degraded status in trying to advocate for greater constitutional protections. I think there's ways to resist that, again, by focusing on the structure and moving away from, Conor, as you helpfully put it, this medicalized understanding of disability. I think the second thing I'll say is I do think under model rule of professional, model rule 8.4G, there might be kind of an ethical obligation, again, to resist these narratives, because failure to do so might promote disability discrimination. So it's something that's provisional. It's something I'm thinking about, kind of a la the debate that you referenced, Professor Owusu. So I think that's the other thing that I would also like to say. And then this last thing, it kind of ties, I think, the comments that Professor Reynolds and Eyer made, as we find ways to resist ableism in legal education, as we have these conversations in the profession and the academy, I think disabled attorneys will be taking a stand on these issues and start to center the lens of disability in a way that I think pushes back against the stigma, serves as a tool to educate courts and juries, and does so with like the depth of advocacy that they're training us, to have in law schools, right? We can do this. If there's anyone that can use language creatively to push back against systems, it should be lawyers. And so that's where my optimism sort of comes from.
This is Conor Dwyer Reynolds. I will briefly respond to the affirmatively furthering fair housing question. I'm not a housing law expert, so I can't say in the specific AFFH context how that intersects with asthma. But what I can say is that in general, lower courts have interpreted the Clean Air Act as, oh, did I go on mute for a second? Did you hear anything of what I said? Okay. So, courts,
we heard you.
Okay, courts preempted, courts generally, often, not always, but have often seen the Clean Air Act as preempting the use of other federal statutes to regulate clean air. That being said, there's kind of this lost history from the late 90s and early 2000s of people using the Americans with Disabilities Act to regulate things like field burning, right? And so actually in the 2000s, it was an open question of whether or not the Clean Air Act preempted the Americans with Disabilities Act, and the Department of Justice actually wrote a memo suggesting that they were complementary statutes and that you could use the Americans with Disabilities Act to go beyond the floor set by the Clean Air Act. It was a brief moment in time that was kind of forgotten. It's actually still an undecided question in the courts. It's just never really been brought up in the last 15 years. But it is to say that the use of statutes that are traditionally seen as being within the disability rights context, using those in the environmental context could be a really important and fascinating way of both increasing protections for people with disabilities while also changing the broader conversation in the environmental law context about where disability fits in. And so that's what I'll just say is that this point that you're bringing up about AFFH is a really fascinating one, and I'd love to dig into it more.
Great. So this has been a fantastic panel that we could ask more questions, and I'm sure there are more responses that could be given, but we do have an accessibility mission, and we want to respect the break. So we'll close there. I'm not sure, Matt, if you have any other comments, so I'll pass it back to you in the meantime.
Thank you so much, Professor Ossei-Owusu, and this is Matthew. And totally agreed. This was such a riveting conversation, and could have gone on much longer. I think there are a few ideas here that could generate panel conferences on their own. So what we're going to do is, like with the roundtable, we're going to save the questions that everyone submitted and post them to our Dropbox. Encourage anyone who wants to think a little bit more about these issues to check those out. And it's totally fair game if future panelists want to actually reference any of those questions or bring up ideas that came up, just to have interactions between the ideas of the panels. But those will be accessible to everyone if you want to take a look. Let me call up Ashlyn for our final continuing legal education announcement for the panel. Ashlyn.
Hi. So if you're seeking CLE credit, please know this is the third and final password. Please write down this password and enter the passwords on your digital evaluation form once the event is over. The evaluation form, again, is mandatory to receive CLE credits. The link to the digital evaluation form was emailed to you in your event reminder email. But if you did not receive this email, please find the link again in the chat. I will post it there. These passwords will tell us how long you attended. The final password for this panel is TACO, TACO, TACO. Thanks.
Thank you, Ashlyn. All right, we're on a lunch break until 1:00 p.m. For our fourth panel, The View from Practice. We look forward to seeing you then.